is most important. Anyone that's important is last will. We do plus will and living trust. We do one by one. Yeah. That's your name. I presently of city, Los Angeles, California, declare that this is my last will and testament. Meaning the last will. So many, when you die, so many will. If you have any much the property, much money, in case so many will. For example, the almost billion, so much the amount somebody left, and he died. And so many person is the will make, and he gonna give me all his property, or he borrowed the money $1 million. They make them. That's so important. That's the reason for that the two person is the that's if we're making that the will, that's so important. This is the last will. That's so important. Former time, even 1 month ago, I made a will, and then the last time, this is the last will. Just this one is the only can use it. The other one is cannot use the last will and testimony of my name, and then my name, Pleasant of Los Angeles, California, declare that this is my last will and the testament. Preliminary declaration, prior will, and codicil. Codicil is also same meaning will. I revoke all prior wills and codicils. I revoke all prior will. Current children, I do not have any living children, or I have 2 children, or something like that. I do not have any living children. 3. The term child or children as used in this will include the above listed children and any children of mine that are subsequent, born or legally adopted. Even adopt children is also same right. So I was born, children, same thing. Executor definition. The expression the executor used throughout his will include either the singular or plural number, or the masculine or feminine gender as appropriate, whether the fact or contact so require. The terms executor in this will is synonymous with and include the terms person, representative, and executrix. Appointment, I appointment somebody, California, as the executor of this will. I appointment two person is the witness, Mr. So and Miss So, two person. Number 6, no bond or other security of any kind will be required of any executor appointed in this will. Power of my executor. I give and appoint to my executor the following duty and powers with respect to my estate. To pay my legally enforceable debt, funeral expense, and all expense is a connection with the administration of my assets and the trust created by this will as soon as forever. Next page. Convenient after my death. If any of the real property divided in this will remains subject to a mortgage at the time of my death, then I declare that the devisee taking that mortgage property will take the property subject to that mortgage, and that the devisee will not be entitled to have the mortgage set out or reserved from the remaining assets of the reside of my estate. If my parents not leaving that any property, any cash, just a debt, so many debt, and then in case also that should I pay? But if I don't have any income, a parent is not much the money, but that is more than they left. In case I give up the any property, I'm not accept. If you not accept any property, you don't pay any debt. But if you received any property, any money, and you should pay for the you take the paper.
Oh, this one.
Yeah. Okay, B, to take all legal action to have the probate of this will completed quickly and simply as possible, and as free as possible from any court supervision under the laws of the state of California. C, to retain, exchange, insure, repair, improve, sell, or dispose of any and all personal property belonging to my estate as my executor deems of individual advisable without liability for loss or depreciation. D, to invest, manage, leave, rent, exchange, mortgage, sell, dispose of, or give option without being limited as to terms, and to insure, repair, improve, or add to, or otherwise deal with any and all real property belonging to my estate as my executor deems advisable without liability for loss or depreciation. E, to purchase, maintain, convert, and liquidate investment or securities, and to both stop or exercise any option concerning any investment or security without liability for loss. F. To open or close bank accounts. E. To maintain continuous dissolve, change or sell any business which is part of my estate, or to purchase any business if deemed necessary or beneficial of my estate by my executor. If you have any property, if you have any business property, this space you put right down. H. To maintain, settle, abandon, or to defend, or otherwise deal with any lawsuit against my estate. I. To employ any lawyer, accountant, or other professional. And J. Except as otherwise provided in this will, to act as my trustee by holding in trust the share of any minor beneficially, and to keep such share invested, pay the income or capital or as much or of either or both as my executor consider advisable for my maintenance. As possible, you should come to right time. Somebody, any immigration person, they come to 9 o'clock, and then they should check it out. But some students come to the 10 o'clock, they say, no, he's not coming. As possible, even come to the sleeping, come to right time, 9 o'clock. Almost 60% is come to the before the 10:25, as possible coming that time. Okay, page 3, education, advancement, or benefit of such minor beneficially, and to pay or transfer the capital of such a share or of the amount remaining of that share to such beneficially, when he or she reach the age of majority or during the minority of such beneficially, to pay or transfer such a share to any parent or guardian of such beneficiary subject to like conditions, and the receipt of any such parent or guardian's discharge by executor. Number 8. The above method. Number 8. Oh, yeah. Number 8. The above authority and power granted to my executor and are in addition to any power and elective right conferred by state or federal law or by other provision of this will, and may be exercised as often as required and without application to or approval by any court. Dispositional estate. any estate. Number 9, payment of debt and expenses. I direct that any debt owed, including but not limited to expenses associated with the probate of this will, the payment of tax, funeral expense, or any other expense resulting from the administration of this will be paid first from my estate. Number 10, disposition of property, except as otherwise provided in this will. All of the property that I own at my death, or which may become payable to my estate or my executor, and any property that I have the power to dispose of under this will be distributed to the trustee of the something. Dated December 6, 2022, that's every time you change the date, to be administered and distributed as power under that trust. General provision, trust this definition, the expression my trustee, and throughout this will include either the singular or plural number, or the masculine or feminine gender as appropriate, whether the fact or contact to require. 12. Insufficient estate. In the value of my estate is insufficient to fulfill all of the bequests described in this will, then I give my executor full authority to decrease each bequest by a proportionate amount. Number 13, page 4, no contest provision. If any beneficiary under this will contest in any court any of the provisions of this will, then each and all such persons shall not be entitled to any divine seed, legacy, bequest, or benefit under this will or any condition hereto, and such invest or share in my estate shall be disposed of as if the contesting beneficiary had not survived me. 14. Similarity. If any provisions of this will are deemed unenforceable, the remaining provision will remains in full force and effect. If witness whereof witness we need at least 2 persons, I have signed my name in this the date. For example, today 16th day of October and 2023 at Los Angeles, California, declaring and publishing this instrument as my last will in the presence of the undersigned witness, who witnessed and subscribed in this last will at my request and in my presence. This date is last will date before somebody any will, and then before the date that one is revoked. Here's the name and signature. and signed and declared by somebody named on the today, 16th day of October and 2023, to be trusted last will in our presence at Los Angeles, California, who at the trust's request and the presence of the testator and each other, all being present at the same time, have signed our name as witness under this penalty of perjury. Witness one, signature. Witness two, signature. Witness three, signature. Witness one, name. Witness two, name. Witness three, name. Witness one, street address. Witness two, street address. Witness three, street address. Witness one, city, state. Witness two, city, state. Witness three, city, state. And then at least two person is a witness. Three is better. But witness, it doesn't matter. Witness, this will read or not. Doesn't matter, read or not. They don't have any right to read the witness, meaning just he made right, he made it real. Just a guarantee. He's the main right, and he made the guarantee. I guarantee this witness is made by him. That's the just a will. And then next page is California Revocable Living Trust. First four pages is the will. And then next one, California Revocable Living Trust. They don't have any exact form, any legal form, doesn't matter. He made just a 2-page will, doesn't matter. Or somebody make for the 10-page will, doesn't matter. And will, first 2 or 10 pages made a will. After that, California Revocable Living Trust. Living Trust is all the property, cash, bank account, house, or something like that. If your parent has the much property, but they don't have any will or they don't have any living trust, after dying, your parents after dying, all the property going to the court. Going to court as court make a decision. And then make a decision how long they need it. At least 2 years. 2 years, so long time. But 2 years, at that time, they should pay payment or tax, everything they should pay. If not paid, all the property is gone. At least the bank statement. Bank is they're paying for 3 months, not paying for any payment to the bank. Bank can take the house. After 2 years, that house will be mine. No. After 3 months, that house bank is taken. That's so important. You should know any payment is not paying, even vehicle, even house, not paying 3 months, And that one is you take the paper. You take the paper. And down to page 5, California Revocable Living Trust. A lot of person is lost to property. You take paper. No paper, no more paper. Okay. 5 paging, California Revocable Living Trust. If you have that a lot of brother and sister, that's too terrible. And then to your father leaving a lot of property, a lot of money, and then they fight. A lot of persons say, no, our brother and sister, that's a good person, we're not gonna fight. And then we divide it peacefully. No. But if you brother and sister, after dying, your father and mother fight, to terrible fight. And in that case, living trust, this document, or at least a will, you don't need a fight. Any property divide through the will. Best one is the living trust. At least should make them will. You take the father and mother, had better make them will. Somebody every year make the will, come to the attorney office. I'm gonna change the will for the second son is divorced. We should make that the new will, or some reason I need some different reason making that the will. Will is very important, not to fight. Okay, California Revocable Living Trust. This revocable trust is made this date, 16th day of October 2023, by and between grantor or so grantor meaning giving person, your father and mother, referred to as the grantor, with the mailing address of something. Next one is grantee. Grantee is receiving person. Grantee, me or any other brother's sister, with the mailing address of something. Normally, the same thing. The trustee agreed to hold any property transferred to this trust from whatever source in trust upon the following terms. You should remember OR, finishing grantor, OR, employer, OR. This one is the giving person. Trustee or employee, EE, is receiving the person. Also remember, Article 1. Name of the trust. Trust meaning giving person, your father. Name of the trust. The trust shall be known as the somebody revocable living trust. Trust name one more time. Name of the trust. This trust shall be known as the your father's name revocable living trust. Article 2. Transfer of property. On the date set forth above, the grantor transferred to the trustee and the property described on attachment A, which is attached and incorporated into this trust. The grantor or someone acting on the grantor's behalf may transfer property. During the life of the grantor or by the grantor's will to the trust and lease such a property on at attachment A. Attachment A is for reference only, and any property transferred to this trust, formally or informally, but not listed on attachment A, is also part of the trust, or proper by transfer to the trust, formally or informally, together with the investment and the reinvestment, as well as of any income earned, is sometimes collectively referred to herein as the trust estate. All property transferred to or deposit with the trustee shall be held by its trust for the uses and purpose estimate. Proposal stated herein. Article 3. Life of the grantor. During the life of the grantor, meaning during the life of your father, the trustee shall hold, manage, and administer the trust property and, at the grantor's request, dispose of the net income and the principal. As the absence of any such request, the trustee may pay to the benefit of the grantor and part of the net income and the principal as the trustee deems as advisable, with the full power to accumulate any income not paid and to hold such income and properties for later use. In the event of the grantor become incompetent, the trustee is authorized to use any part or all of the net income and principal for the benefit of the grantor as a trustee deems advisable with full power of accommodate any income not paid and to hold for future use or to advise to the principal. Article 4. Death of the grantor. Death of the grantor meaning death of my father. Often the death of the grantor, except as otherwise set forth below, the trustee shall hold, administer, and dispose to trust estate as follows. Nothing herein shall be considered legal advice. You are encouraged to seek legal advice from an attorney licensed to practice in your jurisdiction before using this form. Next page, number 8. The trustee is the receiving person, children, shall divide the principal and any undistributed income into equal shares to be distributed equally among the following beneficiaries: name, address. If the children is fulfilled, if more than 4, one more paper you make them. The failure of all beneficiaries. In the event of the failure of all beneficiaries, then the trustee shall pay and transfer the trust estate, discharge of this trust to the person or persons who would be entitled to inherit from name of grantor. Name of grantor meaning name of my father. Under the laws of the state of California, had she or he then died unmarried, had he then died unmarried, meaning if he had then died married, but if that the not attaching estate and domicile in the state and possessed only of the property to be distributed. C. Distribution to any person who is under the age of 21. If distribution is to be made to any person who under 18 years of age and who is not taken then a beneficiary of any person of the trust property under any provision of this trust, and the trustee may make the distribution free of all trusts to the minor, to parents of the minor for the minor's benefit, or to a custodian designated by the trustee for the minor, and that distribution shall be represented residually probate estate shall be insufficient to pay for the grantor's funeral expense. Expenses of the administration and all funeral and state tax in the natural estate. Inheritance or like tax, such application shall be paid by the trustee to the extent that they exceed said residually probate estate asset. 3. In making any payment under this article, the trustee may rely upon any estate certificate of the legal representative of the grantor's estate as to the amount of said payment and the person to whom it is to be paid. Article 6. Estate of grantors, notwithstanding the instructions in Article 4 with respect to the distribution of income and principal, the trustee to authorize in his discretion to use the income and principal of the trust from time to time as follows. Nothing herein shall be considered legal advice. You are encouraged to seek legal advice from an attorney licensed practice in your jurisdiction before using this form. Next page. A, to purchase and to retain as investment any securities or other property, real or personal, belonging to the estate of the grantor. B, to make loans and advances to the personal representative of the estate of the grantor on such reasonable terms as it deems advisable. C, the trustee is not obligated to see the application of any funds paid over to the estate of the grantor. Article 7. Trustee power. Trustee power, the living person's power, meaning for children's power, as an extension and not a limitation of all common law and the statutory authority, and except where is a conflict with any other provision in this trust. The trustee shall have the following power and trustee authority. A, to accept and receive property, real or personal, from the grantor meaning father, from the grantor's estate or from any other estate, trust or person, and to hold the same as a part of the trust. B, to collect income, estate, dividends, rent, and profit. C, to retain any part or all of the property, real or personal, received to be held in trust. Hereunder, in the form of investment, and to invest and reinvest of the property of the trustee in any investment of the trust may deem proper without regard of the principles for diversification, or whether any form of investment would ordinary and considered as suitable for a trustee to make or hold, and to retain any real estate or tangible personal property received to be held in trust hereunder, and or to acquire any real property and or tangible person property permitting the beneficiaries to make such use otherwise as is advisable and formally commensurately with their beneficiaries, their beneficial interest, and to make repair and improvement and pay tax, insurance, premiums, and other charges with respect thereto, as a trustee may deem advisable. 2. D. To sell any real or personal property of the trust at public or private sale for cash or on credit, or to exchange the same or terms as the trust may deem advisable to lease any real or personal property of the trust at times and on terms as the trust may deem advisable, whether or not the lease may extend it beyond the terms of any trust. E. To borrow for the purpose of the trust and to mortgage or appraise any real estate or personal property, any security for any such loans. F. To foreclose by the entry or otherwise extend, assign, or give partial release of any mortgages to discharge mortgages or liens on real or personal property. G. To sign, real, execute, and release all other and necessary convenience and instrument for the purpose of the trust. To sign, seal, execute, and deliver all proper and necessary convenience and instrument for the purpose of the trust. H. To grant option for the sale or exchange or any other property. Next page. I. To both in person or by proxy open all stocks or other securities held and to exercise all conversion, subscription, voting, and other right of whatever nature pertaining to the property of the trust, and to pay any sums any may be deemed advisable in connection otherwise, and to exercise stock option. J. To participate in any plan of recognition, consolidation, or merger to deposit any property of the trust under any such plan or with any protective or recognition commit to delegate to such commit discretionary power with the respect thereto, to pay proportionate part of the expenses of the commit and any assessment revived under any plan, and to accept and retain new security received the portion of any plan. To hold the security K, to hold the security of any real or other personal property in the name of a nominee or nominees or in any other forms. L. To employ legal counsel, investment counsel, and agent to divide whether or not to act upon their recommendation, and to pay them reasonable conventional compensation from the trust estate. long story, not interesting. And to take any proceeding as to law or in equity with reference to or in any matter concerning the trust and to represent the interest of the trust in any proceedings with the power to compromise or refer to arbitration any dispute in any way affecting the same, and to take, accept, to take steps, and to do any act which may be deemed necessary or proper for the due care and management of the trust, or to value all property to be divided or distributed at then current fair market value, and in the trustee discretion to convert all or any part of such property into money and to make a division or distribution thereof in kinds or in any money. To refuse to accept the property as a trustee, except if such a property could result in liability to this trust or otherwise impair the value of any trust property. Q. To property any portion or all the trust funds in any custodial or agency account or other similar account administered by a banking institution or trust company, and to rely upon their investment decisions, such not constituting unauthorized delegation of the trustee's duty, providing that the paragraph shall not be applicable if the trustee is a corporate trustee. To have dealing between or among separate trusts or trustee shares hereunder, including the purchase, sale, or exchange of asset, or the borrowing or lending of money on such reasonable terms and may be appropriate in the circumstances. To open and maintain checking or savings account in any bank or banks, and to designate and one or more persons to execute checks or make withdrawal therefrom. Next page. T. To make loans to any person or persons upon such reasonable terms as the trustee may determine, provided that no loan shall be made to any person who's also serving as a trustee hereunder. Article 8. Payment of premiums. The trustee shall in no way be bound to pay the premiums or other changes or on any policy payable hereunder, nor to see that any such policy is kept in force, but shall use its best effort to collect any sum payable thereunder, whenever by the terms of such policy or policies, the same shall be payable to the trustee, and it shall have knowledge thereof. Article 9, distributions by trustee. Distribution by trustee. Limitation on exercise of special power of appointment. The trustee is authorized to make payment of principal or income directly to and otherwise to deal with minors as through a full age, or to make some such payment for the benefit of such minor, or to the parent or person having custody of the minor for his or her use, as of the trustee may designate. No guarantee or holder or of any special power of appointment granted under this trust shall have the right or power to exercise such a special power in any manner that can satisfy any legal obligation of such grantee or holder, including but not limited to any legal obligation of support. Article 10, accounting unless directed otherwise by another beneficiary of the trust, the trustee may accept such an amount of property distributed to it by the legal representative of the grantor estate as constituting of the property to which the trustee entitled under the grantor's will. The trustee shall have no duty to review the administration of the grantor's estate by such legal representative unless the trustee has the actual affirmative knowledge of any inappropriate in such administration. Article 11, spending thrifty provision. The interest of any beneficiary in any share out of this trust, both principal and income, shall not be alienable, assignable, attachable, transferable, nor paid by way to anticipation, nor in compliance with any other assignment or covenants, and shall not be applied to or held liable for any of his or her debt or obligation, either in law or equity, and shall not be any events passed to his or her assignee or trustee under any instrument, nor under any insolvency or bankruptcy law, and shall not be subject to the interest or control, conditional, spice or other. Nothing contained in the article shall be construed as restricting in any way to exercise of any power of appointment granted herein. Article 12. Dealing with the third parties. Any person, firm, corporation, or entity dealing with the trustee may always rely upon the trustee as being duly authorized hereunder in all particulars, and no such persons, form corporations, or entitled in entities shall be any way too responsible for the proper use or application of any property delivered, or any funds paid over or advanced by any of them to the trustee, and the receipt of the trustee for any payment or any advance made to the trustee, or for any property delivered to the trustee, shall be complete discharge any repeatance to the extent specified in such a receipt. Person delivering with the trustee shall look only to the property administered by the trustee for payment of claim, not to be trustee personal property. Almost finished. Next time, I'm not gonna this kind of long story. I'm not gonna do. That's too long. Article 13. Successor trustee and other provisions dealing with the trustee. But this document is so important that even headache so important you sure to receiving. A successor's trustee. The grantor appoint somebody, one person, with the mailing address of his address as initial successor trustee, and if he shall die or otherwise be unable to fulfill the duty therein, the grantors appoint second person with the mailing address or something as second successor trustee. In the event of neither is able to serve, then the person or persons holding the power to appoint may appoint a corporate or individual trustee to serve as successor trustee. If a beneficiary of this trust is to be appointed as trustee, legal or tax counsel should first be consulted with respect to any possible income, gift, or estate tax consequences to such beneficiary under the existing law. Notwithstanding the foregoing, as long as one trustee is serving here under, no vacancy shall be deemed to exist in the office of trustee. Appointment of a co-trustee by an individual trust. Any individual who is serving as a trust may at any time appoint another person or a corporate trustee to serve as a co-trustee, but only during the period of time that such individual is serving as a trustee. The trustee has the right to remove such co-trustee from such office, with or without course, upon written notice thereof mailed or delivered to such appointed to the trustee. C. Removal or incompetency. During the grantor's lifetime, the grantor shall have the right to remove any trustee should have any trustee hereunder become incompetent as the determined person to this in the indenture or otherwise, such a person shall cease to serve as trustee, and the office of trustee shall be deemed vacant if no other trustee is then serving. Resignation of trustee. Any trustee hereunder may resign by a notice in writing delivered to the grantor. If the grantor is then living and after the grantor's death, to all current beneficiaries of this trustee. Certified copies and certificate of trustee or attorney at law. Anyone may rely upon a copy of hereof certified of a notary public to be true copy of this instrument. Trustee account. Trustee other than the grantor trustee may and often request of any beneficiary thereof shall render periodic account with respect to the trustee hereunder to the person or persons that are entitled to receive any income or principal from the trustee bond. The grantor direct that no trustee hereunder be required to furnish the bond or surely or any bond for the performance to the duty as a trustee in jurisdiction. The rest one is the just to govern. Law is the in California law we're gonna find the governing law in the gender reference. Everything is law is by the California. That's not important. Just to review. And then last page also at least two or more witness we needed. And then this document is the last one. It's notary public. We should make them. Not interesting. This document. Next time, we should interesting paper. This this one is the just a document for law. We should remember and then document. Yeah, that's good job today. Okay.
Last will.
Kita po yung class na.
Susunod ako basta to. Wala na tiga.
Okay, ano tayo sa bayan?